The story refuses to die. Just when Washington thinks it has finally outrun the shadow, it circles back, louder, sharper, more relentless than before. This time, the name pulling it back into the spotlight is one of the most recognizable in modern political history. Bill Clinton is reportedly set for a deposition in connection with the long-running investigation tied to Jeffrey Epstein, and the political world is bracing for impact. Because whenever the past resurfaces in a case this charged, it doesn't just reopen old files, it reopens old wounds, old alliances, and old suspicions that never fully disappeared. For years, the Epstein saga has hovered like a storm cloud over institutions that once seemed untouchable. What began as criminal allegations against a financier with elite connections evolved into something far bigger, a sprawling, unresolved web of relationships, unanswered questions, and public mistrust. The death of Jeffrey Epstein in federal custody in 2019 intensified scrutiny rather than ending it. It transformed a criminal case into a cultural flashpoint. And now, the possibility of a formal deposition involving a former president signals that this chapter is far from closed. Bill Clinton's association with Epstein has been publicly documented in the past, primarily through flight logs and social connections that placed them in overlapping circles during the early 2000s. Clinton has consistently denied any knowledge of Epstein's criminal activities and has stated he severed contact long before the financier's arrest. But in an environment shaped by skepticism and social media magnification, denials alone rarely quiet the noise. A deposition, if it proceeds, would represent a formal, sworn moment, one that carries weight beyond headlines and speculation. To understand why this matters now, you have to understand the larger context. The Epstein investigation has evolved over multiple jurisdictions, involving federal prosecutors, civil lawsuits, and ongoing efforts by victims seeking accountability. In 2022, Ghislaine Maxwell was sentenced to 20 years in prison for her role in recruiting and grooming minors for Epstein's abuse. That conviction was significant, but it did not resolve broader public demands for clarity about the powerful individuals who moved within Epstein's orbit. For many, the central question has never been limited to criminal guilt. It has been about transparency. Clinton's team has previously emphasized that he traveled on Epstein's plane for humanitarian missions tied to the Clinton Foundation, often accompanied by staff and Secret Service. Public statements from his office have underscored that he was unaware of Epstein's crimes and had no involvement in any wrongdoing. Still, in a climate where institutions are routinely questioned, proximity can be politically combustible even when no criminal conduct is alleged. A deposition introduces a different dimension. It shifts the conversation from past press releases to direct legal testimony. Depositions are not trials. They are formal interviews conducted under oath, typically part of civil litigation or investigative proceedings. They can be strategic, procedural, or exploratory, but they are also moments of risk. Words matter, details matter, memory gaps matter. In high-profile cases, even the tone of a response can fuel days of analysis. If Clinton is deposed, the event will almost certainly be dissected in real time by commentators across the political spectrum. The political implications are layered. Clinton remains a significant figure in the Democratic Party, even years after leaving office. His legacy, marked by economic expansion, welfare reform, and international diplomacy, is complex. Adding a deposition tied to one of the most controversial investigations in recent history injects fresh volatility into that legacy. For Republicans, it may serve as a talking point about accountability. For Democrats, it may raise concerns about renewed media focus on a narrative they would rather see resolved. But beyond partisan calculations lies a deeper tension: the public's relationship with power. The Epstein case crystallized a suspicion that wealth and influence can insulate individuals from consequences. Each new development, whether it involves court filings or depositions, taps into that suspicion. It reinforces the idea that the full story has yet to be told. And when a former president becomes part of that legal landscape, even as a witness, the symbolism is unavoidable. Clinton is not accused of criminal conduct in connection with Epstein. That distinction is critical. However, in the era of viral headlines and truncated context, nuance often struggles to survive. The mere announcement of a deposition can ignite speculation. That speculation, amplified across platforms, can shape public perception long before any transcript becomes public. In high-stakes narratives, perception can move faster than evidence. There is also the legal dimension to consider. Civil cases connected to Epstein's victims have continued to move through the courts, sometimes resulting in settlements, sometimes in procedural battles over access to documents. Depositions in such cases often seek to clarify timelines, relationships, and awareness. They can be narrow in scope or broader in inquiry. What makes this situation distinct is the stature of the individual involved. A former president answering questions under oath carries institutional gravity. The timing adds another layer. As election cycles intensify and political rhetoric sharpens, any development tied to prominent figures can ripple outward. Even if the deposition remains strictly legal in nature, it will inevitably be interpreted through political lenses. Allies will frame it as routine cooperation. Critics may frame it as overdue scrutiny. The truth, as often happens, will likely reside somewhere in the details that only the formal process can illuminate. The Epstein saga has already altered the public conversation about elite accountability. It has forced media organizations to revisit past coverage. It has led to document releases and investigative reporting that stretched across continents. It has prompted debates about prosecutorial discretion and plea agreements, particularly the controversial 2008 non-prosecution agreement that shielded Epstein from federal charges at the time. Each development has deepened public insistence on transparency. A deposition involving Clinton would not by itself resolve that insistence, but it would represent a tangible step in a process that many believe has been too opaque. It would place questions and answers into a sworn record, and in a case defined by mistrust, sworn records matter. The emotional weight of this story is inseparable from the victims at its center. For them, the case is not about political calculus or reputational risk. It is about acknowledgement, justice, and closure. Each legal proceeding, whether criminal, civil, or procedural, becomes part of that broader quest. When high-profile figures participate in those proceedings, the signal to the public is that no connection is too powerful to examine. Whether that signal ultimately satisfies public demand remains to be seen. Clinton's legacy has weathered controversy before. From impeachment battles in the 1990s to scrutiny over post-presidential fundraising, his career has unfolded in cycles of challenge and resilience. Supporters argue that he has consistently cooperated with lawful inquiries. Critics argue that unanswered questions linger. A deposition tied to Epstein revives that dynamic in a new context, shaped by a digital age that amplifies every detail. The broader question is not only what will be asked, but how the answers will resonate. In politically charged environments, narratives often harden quickly. A single phrase can be clipped and circulated. A clarification can be overshadowed by interpretation. For Clinton's legal team, preparation will be meticulous. For observers, anticipation will be intense. What makes this moment uniquely combustible is the intersection of three forces: unresolved public anger over Epstein's crimes, deep polarization in American politics, and enduring fascination with presidential legacies. When those forces converge, even procedural steps can feel seismic. As the possibility of a deposition becomes reality, the story shifts from speculation to process. And process in this case is everything. The oath, the questions, the transcript, each element becomes part of a permanent record. Whether that record brings clarity or fuels further debate will depend on what emerges within it. For now, one thing is certain: the Epstein investigation remains a live wire in the national conversation, and the inclusion of Bill Clinton in its legal orbit ensures that attention will only intensify. The past is not merely revisiting the present, it is demanding answers from it. And in a system built on sworn testimony and public accountability, those answers, however complex, will carry consequences far beyond a single room where questions are asked and answered under oath. The deposition, if conducted, will not be a spectacle in the traditional sense. There will be no televised cross-examinations, no live courtroom drama. Yet its impact could reverberate just as powerfully. In the digital era, transcripts travel fast, summaries spread faster, analysis becomes instant. Within minutes of any substantive disclosure, commentators from cable news to independent podcasts will parse every line, hunting for implications. The quiet room where testimony is taken may be private, but the echoes will be public. Part of the intensity surrounding this development stems from the long arc of the Epstein case itself. When Epstein was first charged in Florida in the mid-2000s, the outcome, a controversial plea deal that avoided federal prosecution, sparked criticism but did not ignite the global outcry seen years later. It was only after investigative reporting revived attention to the case that federal authorities in New York brought new charges in 2019. Epstein's subsequent death in custody transformed a prosecution into a permanent mystery. The vacuum left behind invited speculation that has never fully subsided. Into that vacuum stepped a demand for accountability that transcended party lines. Lawmakers from both parties called for document releases. Judges weighed requests to unseal records. Victims pursued civil suits against institutions and individuals they believed enabled abuse. The legal system, slow and methodical by design, has been moving through those requests step by step. A deposition involving a former president fits into that pattern, not as a headline-grabbing anomaly, but as part of a broader effort to establish factual clarity. Still, the symbolism is unavoidable. Bill Clinton is not just another public figure. He is a two-term president whose political network spans decades. His post-White House life has included global philanthropy, high-profile speeches, and continued influence within Democratic circles. For some Americans, he represents a period of economic growth and diplomatic engagement. For others, he represents unresolved controversies. In either case, his name carries weight. That weight magnifies scrutiny. Even if the deposition centers on narrow factual questions, dates, meetings, travel logs, the surrounding narrative will expand outward. Analysts will revisit archived photos and flight manifests. Political operatives will test messages. Social media will erupt with interpretations that range from cautious to explosive. The legal proceeding may be technical, but the cultural response will be anything but. It is important to separate legal reality from rhetorical intensity. Being deposed does not imply wrongdoing. Witnesses in civil and investigative proceedings are routinely asked to provide sworn testimony because they may possess relevant information. Yet in high-profile contexts, nuance competes with narrative. The challenge for institutions and for the public is to resist the temptation to treat process as proof. There is also a historical dimension. Former presidents have given depositions before. Clinton himself provided testimony during investigations in the 1990s, including in the case brought by Paula Jones. Those moments demonstrated that even the highest office does not confer immunity from legal inquiry. They also illustrated how legal processes can intersect with political storms. The memory of that era adds an additional layer of resonance to the present development. Meanwhile, victims' advocates continue to emphasize that the central focus should remain on those harmed by Epstein's actions. For them, each procedural step represents a chance to illuminate systems that failed. They argue that transparency deters future abuse by signaling that influence cannot permanently shield individuals from scrutiny. Whether a deposition yields dramatic revelations or simply confirms known timelines, its existence reinforces the principle that testimony matters. The coming weeks could prove pivotal. If a deposition proceeds, questions will likely probe the nature of Clinton's interactions with Epstein, the context in which they met, and the extent of any awareness regarding allegations. Lawyers will frame inquiries carefully. Objections may arise, answers will be measured, and when it concludes, the story will enter a new phase defined not by anticipation, but by interpretation. In a political climate already charged with distrust, interpretation can shape reality. Supporters may view cooperation as evidence of confidence. Critics may seize on ambiguities. Media outlets will compete to contextualize fragments of information within broader narratives about elite networks and institutional accountability. The risk of distortion is real, so is the opportunity for clarity. At its core, this moment underscores a tension at the heart of democratic systems, the balance between reputational protection and public transparency. High-profile figures have legitimate interests in safeguarding their legacies. The public has a legitimate interest in understanding the full scope of investigations tied to serious crimes. Depositions sit at that intersection. They are tools of inquiry, not verdicts, but tools that can reshape conversations. The Epstein case has already altered the landscape of public trust. It exposed weaknesses in prosecutorial oversight. It highlighted disparities in how wealth and status intersect with justice. And it galvanized a generation of citizens who demand more openness from institutions. Against that backdrop, any development involving prominent names becomes more than procedural. It becomes symbolic. For Bill Clinton, the path forward will likely emphasize cooperation and consistency with prior statements. For investigators and attorneys, the objective will be precision. For the public, the reaction will unfold in waves: initial shock, analytical deep dives, partisan framing, and eventual recalibration as new information either confirms or complicates existing understandings. No matter the outcome, one reality stands firm. The Epstein investigation continues to ripple outward years after the central figure's death. Its aftershocks reach into boardrooms, courtrooms, and now potentially into the sworn testimony of a former president. In that sense, the case has evolved beyond any single individual. It has become a referendum on transparency itself. And as the deposition looms, the nation finds itself once again confronting a familiar question. How does a democracy reconcile the gravity of elite association with the presumption of innocence? The answer will not emerge from a single transcript, but the process of asking and answering under oath is part of how that reconciliation begins. What makes this second chapter even more charged is the atmosphere in which it is unfolding. The Epstein investigation no longer exists in isolation. It lives inside a hyper-connected media ecosystem where fragments of information can ignite global reactions in seconds. If BillClinton sits for a deposition, the legal mechanics will be deliberate and controlled, but the public response will be instantaneous and unpredictable. Every pause, every carefully phrased answer, every "I don't recall" will be scrutinized far beyond the walls of the room in which it is spoken. The gravity of sworn testimony lies in its permanence. Depositions create transcripts that become part of the legal record. They are not campaign speeches or press conferences where language can be reframed hours later. They are statements made under oath with legal consequences for intentional falsehoods. That distinction elevates the stakes. Even if the questions focus narrowly on timelines or travel, the setting transforms ordinary recollection into a matter of record. For Clinton, this is not unfamiliar terrain. His presidency was defined in part by legal confrontations that blurred the line between politics and the courtroom. He has navigated depositions before. He has endured impeachment proceedings and congressional inquiries. But context changes everything. The Epstein case is emotionally charged in a way that few modern investigations have been. It touches on exploitation, abuse of power, and systemic failure. Being linked to that narrative, even peripherally, carries reputational risks that transcend partisanship. There is also the question of memory. The events likely to be discussed occurred decades ago. Human recollection fades, details blur. In ordinary circumstances, that is expected. In a deposition connected to a case of this magnitude, however, imperfect memory can become a flashpoint. Critics may interpret gaps as evasiveness. Supporters may interpret them as natural limitations of time. The transcript will not merely document answers, it will shape interpretation. Beyond the individual, the institutional implications are profound. A former president participating in a deposition tied to a case involving elite misconduct reinforces a foundational democratic principle. No office is above inquiry. That principle is not partisan, it is structural. It sustains public confidence when confidence is fragile. Even the act of appearing, of answering questions under oath, signals that the machinery of accountability continues to function. Yet symbolism cuts both ways. For those who already distrust institutions, the deposition may be viewed through a lens of skepticism. They may question timing, scope, or intent. They may argue that deeper truths remain concealed. In an age where information competes with suspicion, even transparency can be contested. The challenge for the legal system will be to let process speak louder than rhetoric. Meanwhile, political strategists are undoubtedly assessing ripple effects. Though Clinton does not currently hold office, his influence within Democratic networks remains substantial. Fundraising events, campaign appearances, policy advocacy, his presence still matters. A deposition could complicate that role, at least temporarily. Opponents may attempt to frame it as emblematic of broader critiques about political elites. Allies may emphasize the absence of criminal allegations and underscore cooperation. Media coverage will likely oscillate between measured legal analysis and sensational framing. That tension reflects a broader evolution in how high-profile investigations are reported. In earlier eras, developments unfolded at a slower pace. Today, analysis begins before proceedings conclude. Clips circulate without context. Hashtags trend before transcripts are fully read. The narrative can outrun the facts. And yet, beneath the noise, the central question remains straightforward. What information is being sought, and what clarity can it provide? Depositions are tools. They exist to gather sworn statements that may inform civil claims or broader investigative understanding. If the questions are limited, the impact may be limited. If they are expansive, the implications could extend further. The content will determine the consequence. It is equally important to remember what this moment is not. It is not a criminal charge against Clinton. It is not a verdict. It is not proof of wrongdoing. It is a procedural step in a long and complex legal journey connected to one of the most disturbing criminal cases in recent memory. Maintaining that distinction is essential for responsible analysis. Still, perception often shapes reality in politics. The mere image of a former president linked to sworn testimony in the Epstein matter will carry emotional weight. For some, it will feel like overdue scrutiny of powerful networks. For others, it will feel like recycled controversy. The divergence in interpretation reflects deeper divides about trust, accountability, and media narratives. Victims' voices continue to echo through this process. Their lawsuits and advocacy efforts have driven much of the ongoing legal activity. Each deposition, document release, or court ruling represents incremental progress toward fuller understanding. Whether Clinton's testimony yields new insights or confirms previously established facts, it becomes part of that broader mosaic. There is also an international dimension. The Epstein network spanned continents, connecting financiers, academics, politicians, and socialites across borders. Clinton's global profile ensures that any development involving him will attract worldwide attention. Headlines will not be confined to Washington. They will appear in London, Paris, and beyond. The story's reach underscores how interconnected reputations have become. As anticipation builds, legal teams will likely focus on precision. Preparation for a deposition at this level involves reviewing calendars, correspondence, travel records, and public statements. Consistency is critical. Any discrepancy between past remarks and sworn testimony can fuel controversy. The objective is not theatrical performance, but disciplined accuracy. When the deposition concludes, attention will shift to what becomes public. Some depositions remain sealed for extended periods. Others are partially disclosed through court filings. If excerpts emerge, they will dominate news cycles. Analysts will compare statements to existing evidence. Lawmakers may respond. The cycle of reaction will begin anew. In the broader arc of American political history, moments like this illustrate how legacies evolve. They are not static monuments. They are living narratives shaped by ongoing events. Clinton's presidency will always be associated with economic milestones and geopolitical initiatives. It will also remain intertwined with episodes of legal scrutiny. This deposition, if completed, becomes another chapter in that complex story. Ultimately, the significance of this development lies less in spectacle and more in process. Democracies depend on institutions that can examine powerful figures without fear or favor. The Epstein case, painful and unfinished, continues to test that capacity. Each step forward, however, procedural signals that inquiry persists. The coming days may bring intense commentary, but the enduring impact will rest on substance. What was asked, what was answered, what was clarified, and what remains unresolved. In a case defined by unanswered questions, even incremental clarity carries weight. For now, the nation watches, aware that history often turns not on dramatic confrontations, but on quiet moments of sworn testimony. A room, a court reporter, a series of questions. It sounds procedural. It feels routine. Yet within that routine lies the potential to reshape narratives that have lingered for years. Whether this deposition ultimately diffuses speculation or reignites debate, it reinforces a simple but powerful reality. Accountability is not a one-time event. It is an ongoing process. And in the Epstein investigation, that process continues to move, measured, methodical, and watched by a public determined not to look away.